until the moment we leave the room.
Okay, so strong with the force you are, you will solve this case. Thank you for asking me. My name is Krisztian Kovacs. I'm coming from Hungary, Budapest, and I'm really happy to deliver you this kind of interesting topic of insolvency law. Being involved in a presentation, I think, is very important for you, even to not to sleep. So I would like to ask you, what do you think? Who's of you going to take apart the company is going to be bankrupt, an insolvent one? It's not a hot topic, right? Not really. We should, at least we should, say to our students, there are no bad questions, there are no stupid questions, there are no stupid students as well. But 2 years ago, one of my students just came to my office. Oh, Chris, this is how they call me, the university. Chris, I have a very interesting topic. I already wrote roughly 20 pages. I'm delighted. Oh, and what's your topic? State competitiveness. You know, there are these charts, and they are saying these are important factors. And insolvency law often takes place in these kind of charts. And I'm totally impressed. And what's your topic? It's piece of... Why? Because no one goes to a state to go bankrupt. And okay, there are no stupid questions, there are no stupid students, but I would say a reasonable man could consider this question a stupid question. So, we are not talking about insolvency law because anyone wants to go bankrupt. We are talking about insolvency law because one of your clients may be a creditor to a company which goes bankrupt. This is why it's important to know the rules, even the basics. Before the accession to the European Union, was Poland, Hungary, and other states as well didn't harmonize the law of insolvency. Insolvency law is still a law of national law. No EU-wide, there is no real harmonization, there are no directives, only few regulations according to insolvency matter, only on jurisdiction and on recognition. In the 1980s or maybe 70s, few guys started to complain about, oh, why not unify insolvency law? What do you think? What was the reason why not unify? It's easy. If you want to unify something, what would you do? To ask a guy to present us a better law that we already have, a better one. It means that not our law is the best. We should change it. And if you have to confess in front of several, much more very sophisticated persons that your law is not good enough, you're totally lost. And this is what happens exactly when the guys in the EU want to recast the regulations. They send questionnaires to experts, to scholars. And what happens all the time? What are the problems in your country according to the application of this kind of regulation directive? Doesn't really matter. Oh, there is no problem, everything's okay. We are really good students, there are no problems. What happens? Everything remains the same. This is the main problem, implementing or unifying new laws. So, before 2004, there was no multilateral treaty or something like that. Therefore, how should an insolvency, more specifically liquidation, could be recognized by the states. There was no such procedure. It could be mutual recognition, committee, things like that, but there was no clear recognition of liquidation awards. Then, as we joined the European Union, the EC regulation on insolvency procedures became binding for us, both for Poland, both for Hungary. And this insolvency regulation only deal with the matter of jurisdiction, which court may assess the specific insolvency procedure, and if one court finds that it has jurisdiction over this matter, the other courts must recognize this jurisdiction and divided the scheme of liquidation, more specifically liquidation procedures, to two types of procedures. One type of procedure is the main procedure. This is the most important procedure. And the other procedures are the secondary procedures. There are no necessarily be even one secondary procedure. The certain is always the main procedure. The main procedure decides what is the applicable law to ancillary proceedings. For example, this kind of ancillary proceeding is the liability of managers. This is why it's very important, not just to be the first one who decide this matter, but the applicable law, substantive law, depends on the main procedure. The secondary procedures are just to distribute the assets of the insolvent company. Doesn't really matter in this kind of question. The regulation imposed or required the courts dealing with insolvency to cooperate with each other. I know you are so young, younger even than me, and may not have too much cases cross-border, which has cross-border elements. But what do you think? How does this cooperation goes in an everyday life or practice? It goes something like that. So, if you are, let's say, a Hungarian judge, you are dealing with a Hungarian insolvency case. You know there are connections, let's say, in Poland. The company has a subsidiary in Poland. What would you do? How would you approach the Polish judge? You may write an email, but for who? Dear Polish judge, I have an insolvency case there, please cooperate with me. Not really. Or you should ask the official body of your state to get someone to cooperate with. Yeah? Seems to be a nice working scenario, right? For example, in my private practice, we have a very interesting case according to a cartel damage claim, which is consisting around roughly 5 million euros as a claim. One of the claimants, which we represent, got this claim from an assignment, from a contract for an originally damaged person. This guy commenced proceedings against the cartel members, and one of the cartel members sued, or client sued for the declaration of invalidity of the assignment. Because if the assignment were invalid, he is not a claimant. Therefore, the claim shall be dismissed. And till the last year, there was a mandatory requirement in the Hungarian Civil Procedure Code that before the lawsuit, the applicant and the defendant must try to reach an agreement. Try to negotiate this kind of matter. Try to reach settlement. Why? To avoid the lawsuit itself. It's a mandatory requirement, it was, the claimant of the invalidity claim had its seat, I think, in Holland, in the Netherlands, in the Netherlands. Therefore, he interpreted the Hungarian code that he had no such obligation. Why? Because in the civil procedure code, exactly described, this obligation is for companies. But this not in the Netherlands, in Germany, sorry, in the German. This company was an Aktiengesellschaft in Germany. Do you know what is it? Company limited by shares. It's known all of the European countries. Doesn't really matter. But everyone should know it if you type it to Google, the second one. So, what happened? The court immediately dismissed the claim because the negotiation... Okay, we are in a hurry. I will be brief, I promise. So, the court immediately dismissed the claim. What happened? Well, my client really liked to postpone the proceeding for some reason, doesn't really matter why. Therefore, we, as defendants, appealed against the dismissal of the claim. You know, we just, oh, please sue us. We would really like it. Why? To postpone the proceedings. What happened? To our surprise, the court shared their opinion that the immediate dismissal was illegal because the court had not examined what is the content of Aktiengesellschaft. Is it a company in the sense of Hungarian law? What happened next? The court turned to the Ministry of Justice, then the Hungarian Ministry of Justice turned to the German Ministry of Justice, Federal Ministry of Justice, to ask whether an Aktiengesellschaft is a company. The German Ministry of Justice just responded, yes, the Aktiengesellschaft is a company. Then what happened? The Hungarian court dismissed again the claim because the negotiation was never took place between the two companies. This is something how cooperation works, the everyday life, everyday practice. So, what's the importance of the main or secondary procedures according to liquidations? I already mentioned that the main proceeding decides which substantive law, or let's say personal liability, manager's personal liability, applies. Why is it important? Because the determining factor to decide which one is the main proceeding is the center of the company's main interest. We call it COMI. C-O-M-I. Normally, let's say 90% of the cases, the COMI is situated where the company has its seat, but not always. Because the center of the main interest, where the business judgments to be made, when they're conducting their business, where their managers are. So, where the head is. This is the center of the main interest. And sometimes it's situated in different states than the seat. For example, let's say it's a hypothetical case, which happened in my practice. So, let's imagine that there is a German managing director or managing relatively good factory in Germany. The German factory importing goods from Hungary, raw materials, and then producing something and sell it in Germany. In 2015, it turns out that the company is nearly to be insolvent, let's say, something like that. So in 3 or 3 months, it may become insolvent. But the manager would say, it was my action. Oh. So, what's the business judgment? Well, we are buying our raw materials from Hungary. Labor workforce in Hungary is much cheaper than in Germany. Why not to move our business to Hungary? And they are moving their business. 2 months is enough for them. What happens? They are starting the production in Hungary, and 3 or 6 months later, the company becomes insolvent. And liquidation procedure initiated against the company. Where does the company situated in this scenario? In Hungary. The company really moved to Hungary in this case. So, the center of the main interest, even if the seat is not moved in Hungary. Therefore, the main proceeding will be initiated in Hungary. And Hungarian substantive law will apply to the case, to the manager's liability. And there are differences between the Hungarian and the German insolvency regime. In Germany, there is a duty to file, so-called duty to file. If the manager, for the manager, it turns out that the company will become insolvent, he or she must file for liquidation. It's a duty. If not, criminal sentence may be awarded for him, so it's a huge problem. But in Hungary, there is no such requirement. Hungary follows the rule, it's so-called wrongful trading. It doesn't really care if there is an insolvent situation, so long as the manager won't do something nasty, fraud or fraudulent act, something like that. And in this scenario, before the company moved to Hungary, the manager just transferred a small amount of money, 50,000 euros, to his son for some kind of advice. It was a one-page long contract about advisory, about nothing basically. Doesn't really matter. So, what happened? From the perspective of Hungarian law, the manager did something wrong when he foreseen that there will be an insolvent situation. And therefore, according to Hungarian law, he will be personally liable for every impaired loss that the creditor suffered. And personally liable can be sued and must pay this amount of money, but he transferred fraudulently from the company. What's the nasty in the situation? When the manager transferred those amounts of money, he acted under German law. When this rule does not exist and cannot be foreseen, why? Because who decides the transfer of the central main interest to another state? Not the manager. The manager is carrying the task according to this transfer. But who decides? The owners of the company. So, the manager could reasonably foresee what would be the consequence according to German law. But for him, it wasn't foreseeable that he may be liable according to Hungarian law when he transferred the money. But at the end of the day, due to the regulation, the main proceedings were initiated in Hungary, and this manager were personally liable for this fraudulent act in a relatively short term. So this is why it could be important even for you to know the rules and what the center of main interest means. Okay, sorry, I just want to speed up. Yeah, and roughly 2 minutes about the insolvency forum shopping. You know, there is the hard way, there is the easier way, and there is one that you pay your lawyer for. There are 2 ways to move to another country. There is a directive on cross-border merger to just relocate your seat, or you are acting by fact that you are moving your commit to another state. Why is it important? Why could be important? Because you may know that your company is going to be insolvent, let's say, in 6 months. Because very huge amount of money becomes due, for example, from a credit facility agreement. What would you do? You are searching for a very debtor-friendly state within the EU. Why? Because you move there, and if you move there, you as a manager would advise it to your owners, the company's owners, oh, we should move to Germany. Why? Did it involve anything about your personal life? No, it's totally fine, even for you, no. But why not to move to Hungary? No. Because of the personal life? But no, definitely no. It's not the best place for the company and even for you. Why? Because you know that there will be a liquidation, and you have to find the best place for you and for your company to die. You know, all elephants go for the same place to die. Really, the same happened before the new regulation, before 2015. And because of that, there is a presumption in the regulation, even if you move your seat to another member state within the EU for 3 months, the commie will be your previous place. Why? To prevent, or trying to prevent, this kind of fraudulent forum shopping. Therefore, you, as a lawyer, you are paid for, what would you advise? Keep your company alive for 4 months after moving your seat to another country. Thank you very much.
Very quickly, I can't help but ask one quick question. You referred at the beginning to the various charts and categories about the league tables of where it's good to die as a company. So doing business is the one that I would be most familiar with. And the UK which does relatively well in that. If you look at how many pence in the pound or cents in the euro a creditor can expect to get back if a company becomes insolvent. And one of the main reasons for that is that the UK is very good at getting money from directors like the German man that you mentioned in that story. Now those kind of legal provisions exist in every single country, but in some countries they exist on paper, but they're not actually enforced in reality. So in Hungary, are those kind of legal mechanisms for suing a bad or a negligent director, are they used commonly in practice, and can creditors expect the bad directors to have to contribute money back to the company so that it can be then passed on to the creditor?
Well, in Hungary, this rule, exists, to be honest, on the paper. Why? Because if the manager would see that there would be an insolvent situation, that he or she withdrawn for the management, and usually, but the Serbian people pointed out the manager. Why? Because then the Serbian people would be liable for this situation. And there is a possibility to invoke the last 3 years manager's liability, but the defense is usually that it wasn't foreseeable for this manager when he withdrawn for the management, this kind of insolvent situation. And referring to the question regarding the UK, people like to move to the UK to die, but not necessarily to die, because in the UK the chance to restructure your business is much higher than in any other European Union states. For example, I only know a Hungarian example. Out of the 28,000 insolvency procedures of last year, only 100 resulted in reorganization. Every other scenario resulted in liquidation. Therefore, there is no chance to restructure your business. While in the UK, there could be the situation you may restructure your business. Not necessary, but the chance is better. It's on your side.
Okay, well, thank you very much, and with apologies for the sudden rigorous enforcement of timing policy that has been thrust upon us. I would like to invite from the home team Dr. Magdalena Konopatska, and you've all been asked questions so far, individual questions. I believe you have a written exam for the audience, which
I'm asking questions here, so well, given the schedule, yes, we are a bit tight on time. So yeah, could you hand it?
No, I'll hand it out.
You will hand it out. Yes. So there are handouts. There are passes for you. Maybe now. Yeah. It's something probably you should do at home rather than now, or you can do it along the way as I speak. But it's a test for you to test yourselves on what I'm going to talk about. If you're intelligent, probably you could also guess sometimes. Yes, it's just one. The most appropriate answer is correct, right? But probably you can either do it now and swap, and if you want to have grades, then someone will grade your colors, or your mom at home, yes, or your husband, wife. So this is just instead of question and answer session, but I'm talking about mediation in civil and commercial matters compared to the Polish perspectives. I am a mediator, and this is not, I'm not going to read anything which I brought, but it's just to show you when you complete a course is to become a mediator, because I'm going to talk about that there are no formal requirements as to what profession you come from. And so you don't really have to be a lawyer even, or a psychologist for that matter, but that's what you get. Yes? And this is actually the entire training, yes, is in here. But I have to add that I did not have to complete, it's just complementary mediation, civil and commercial mediation, because I did not have to do the entire course, which is a little longer. Probably you would get twice as much materials, because I studied mediation and ADR and arbitration and other things in Ghent when I did my LLM. But so this is just to show you and to assess for you whether you think it's enough to be such to do such a responsible thing. Okay, so what I wanted to talk about, but probably I will boil it down to or I will skip some issues, is definition, origin, and application of the ADR as such, mediation compared to litigation and other methods, efficiency and justice, which is something I absolutely love, and I don't write anything without referring to law and economics in my research, and enforcement of the reached agreement. Then specific features such as phases of mediation or stages, mediators' tasks and duties and quality of mediation, and some law, and some sources of law, but this is going to be just one slide, and the Polish perspective. Although this last thing is probably the most boring in terms of the Jura implementation, because it's like, you know, some articles from the Code of Civil Procedure, but I'll end the quiz, which you have. So the definition, I borrowed one definition from a Center for Effective Dispute Resolution, which is a British one, I think, but there are many more globally. So, but I think this particular one is quite accurate. And there is also, since I'm talking about this directive 2008/52, this comes, the other one comes from this directive. And just one copy, but I can give it to you. If you're here, you don't see anything really.
And I see it as well.
Yeah. Right. So yeah, you can read it. I'm not going to repeat, but the main features in the first, I think the first definition is that it's flexible. I think it's different from the second. Whereas the directive speaks about a structured process, and of course it can be done on a voluntary basis, or it has to be done on a voluntary basis, but on the other hand, it can also be suggested or ordered by court, which means that it's not so voluntary anymore, but on the other hand, when it comes to mediation, which is ordered by the court, you cannot force either party to do it, right? So if the parties don't agree, they don't want to reach an agreement, then they will come back to litigation. And of course it's done with the assistance of a mediator, which we're going to talk about later. Origin and applications. Basically, ADR stands for, you have it in your test, but I will help you, alternative dispute resolution, and basically the main feature of the whole bulk of methods is that it's alternative to what? What is it alternative to? Litigation, of course. So there are many divisions, as you can actually, many ways to divide ADR according to different standards. But one important is that you have criminal and civil mediation. Yes, so when it comes to mediation, it is criminal and civil mediation. Civil including family, commercial, and labor. And another division is that you can have, which I'm referring to Poland right now, especially that you can have pre-trial, ordered, or suggested mediation, which is suggested by the court, but also you can still do it if it's out of the party's own initiative. You can still do it when litigation is in place all along the way. And well, this is a lot of text, but this is basically something which you can also read when you Google my article, Mediation in Closed Circles. It's quite long, and the funny thing is that, well, I did not want to mediate with the Polish Center of Mediation, but what they did is, unfortunately, they published it without consulting me, and actually I filed it like 2 years before, and I said, okay, there are amendments to be made, because I had it in place even earlier. But if you are ready to publish it, then I can translate or not, yes, and just let me know. And they never did. And after a few months, like for example in April of 2015, I came across my own article, which was never proofread by myself, right? So, and also there's one thing at the end, because everything is correct, and it's about history also of origins of ADR, so that's fine, it doesn't change. But the last sentence is that there is a proposal of a directive, and it is meaningful that there is a directive in place, right? right? So I didn't manage to change it. But, well, it originates from access to justice movement in the United States, 1970s. And yes, and basically it's about the granting the possibility of a wide public to have this access to justice without necessarily paying a lot of money, without going through a lot of stress, etc. Right? So this is the idea. But in my article, which, like I said, you can read, and I invite you to download it. It's like open access. I talk about mediation in closed circles, or it's also called self-contained milieu. So we are here at the university, and this is one way to use mediation to avoid certain problems which might arise at universities between students and teachers, and between different stakeholders, right? But so this is one way to do this. And the other one is mediation in the medical field, and here this would also be civil and commercial law as well, yeah? But not necessarily criminal, because it might concern overbilling, errors and omissions, employment, or medical malpractice. Right, but I don't have time to speak more about that. So also, in terms of features of mediation, I will come back to a list, but here is an excerpt, a short excerpt from my article, and you can see that it's very cheap, it's more focused on the parties, on balancing their interests, rather than letting one prevail. And this is important because it is not a zero-sum game, thanks to mediation, when you have a conflict, right? The conflict you perceive normally as a zero-sum game. So if someone loses, someone wins. This is the case in court. Always. There's never a chance that someone, probably even in most cases, both the parties will be dissatisfied with the outcome. Because one loses, obviously he or she is not satisfied, but the one who wins might also have some issues, right? So the only way to counteract this is to go to mediation. Mediators are not restricted by the law, and they can have more flexible ideas and outcomes in the mediation settlement. It's based on fairness. Both parties present their reasons and their griefs, because many times the conflict is not really about what it looks like when you file a lawsuit, for example. It's a lot more behind the lawsuit, yes? It's like years of some problems arising, and you don't resolve it, you cannot resolve it in court. You only do it through mediation. So the mediator looks for all the ways to reconcile conflicting interests and has to facilitate communication, sometimes even threaten the parties a little bit by saying that litigation is a lot more costly and some colors have changed in here. So you have just a list. I'm not going to give you, even an idea of what each of them is. I'm going to speak only about mediation, but you can see, and this could be even longer, right? Arbitration, med-art, so a combination of mediation, then arbitration, the other way around, etc., right? So ADR encompasses all those methods. I also wanted to talk about advantages and disadvantages of ADR as such, but some of those things I have already referred to, showing you the excerpt from my article. Advantages basically are that mediator is not necessarily a lawyer, right? So a judge is a lawyer. The doctrine of judicial precedent, I refer to the common law system here, will be applied, but in civil law, it will also be some legal certainty, which might be prevalent in court. There is an appeal system if a party is unhappy. This is very strict procedural rule. And legal aid is available for those on low income, whereas in ADR, especially in arbitration, you don't have legal aid because you have to pay the arbitrators their fees. And disadvantages of civil courts are that they are expensive because you don't only count in the fees, court fees, but also the time. So, I mean, they're time consuming, but the time is money as well. So there are delays, yes, lengthy proceedings, which end up in Strasbourg, for example, in the case of Poland, very frequently. Procedures are more complex. Courts also are open to public and press, and with respect to commercial proceedings especially, it's not something you want to do. And so you don't really want to reveal your problems, your trade secrets as well. Yes? If there's a conflict between companies, then they might want to turn to something less open, yes, to the public. And also, for example, mediation, the outcome of mediation is never revealed to the public, right? So this is also secrecy. And likewise, arbitration is not all arbitral awards are published, and even if they are, it's very limited information. So, but the judge will not have technical expertise. Yeah? So this is something which arbitrators and even mediators might have. For example, those who are psychologists might be able to communicate with the parties more effectively, efficiently. And the court service or the court chooses the trial date, whereas in mediation or ADR, as such, you are free to do it. I'm going to skip arbitration versus litigation comparison, yes, because this is not strictly the topic. But I'm just going to give you a hint about bond economics of mediation just very briefly. You have some strategies which you employ as a person, and especially if you're in a situation of conflict with another person. And so those strategies can also be used in court, but in mediation they're probably even more evident. And also there are some reasons within game theory why mediation is better than litigation, and why some ways to mediate are better than others. I will just refer to one of the games you put first, and it's a game, it's a theoretical situation where two persons are put in prison. One is guilty, one not. One is like a psychopath, the other is not, is a very timid person. And let's say the prosecutor says, you stay in prison for 20 years, or as long as you agree on who is guilty. Yeah? So the person who confesses will get 5 years of imprisonment, and the one who does not will be set free. But guess who confesses more frequently? I mean, based on research and on empirical studies. The good one. Yeah, the good guy, yes, or girl. Because, why? Because the bad guy just enjoys it, yeah? Enjoys his time in prison, and bullying the other person is especially good, right? So there's one reason why mediation lets you, in a way, it will let you be on equal footing with the other person, but only if this person is not a psychopath, right? If he is, then, for example, you would choose mediation, which is indirect. So the mediator meets up with both parties or all parties separately, right? So this is also the reason behind it. And some psychological principles which are proposed or I don't know if you've heard of GLD, but probably you have, yes, persuasion and making people do what you want was the topic of his books, has been. So you, basically, your actions are based on the principle of reciprocity, and this is very important in mediation, yes? You make contingencies, yes? You agree to something when the other person does, right? So reciprocity is important. And for example, consensus, yes? Consensus because you prefer to do something which is also done by your peers, yes? So, and which is also, for example, advocated by some authority. So authority is also here. Consistency, you want to be consistent with something you have previously done. So also this is an explanation why mediation is very frequently more efficient than a judgment which has to be enforced, because parties tend to stick to their values and their decisions, yes, which they have made out of their own will, and this is done in mediation, not in court. Right? So you don't really need enforcement very frequently because they will do as they promised. Oh, this I'm going to skip. And also, well, this is the last of the economics and psychology issues behind mediation and litigation and ways to mediate, because you have here a very evident clash between legal norms and social norms. Yeah, so something I have referred to before. Legal norms are imposed on people by the court, yes, by the police, etc. Whereas social norms are something which you have inside, or it's done by your peers, by everyone else around, so that's why you want to follow. And that's why, because there can also be mediation which is out of court and which is non-binding even, right? And sometimes you want to have your agreement approved by the court, and then it becomes binding. So basically, gentle nudges, yes, is something more efficient, more effective than hard shows. Hard show, I would say that it's something done by the court. You are ordered to do something, yes? And gentle nudge is something the mediator has to do, yes? Just to kind of make you do something because you like it, because you want it, and because it's nice. Also when we refer to the Cialdini's 6 principles, the psychological ones. And the examples here are different. It's about, for example, Marmite. Instead of, I don't know, placing a sanction on people who chew their gums and throw them away, you would rather install something like that on bus stops. And Marmite, you love it or you hate it. Yes, you have to say that probably you actually do hate it most frequently, but sometimes you love it. Yes, and you prefer to do something which attracts you. You stick the gum rather than just throw it away. Yes, and you know it's for children. This thing here. And also, we all sort at Brussels airport is another example of showing that you should do something because it's better, yes, because we all do it. Okay, so now coming to the more strict issues and legal issues. When you look at it, there are stages of mediation which range from 4 to 8. Well, whenever in the literature, yes, you can have different levels of generalization. Yes. So this one is a very the one which is advocated by the European Union. It consists of 6 stages. Yes, this model, and it is the opening stage. It is the statement of the problem by the parties, right? So the mediator invites everyone and welcomes everyone. Then he invites people, the parties, to tell what the problems are. Then identification of the issues and determination of the agenda, because it also has to be timely, yes, and it has to be expedient, so the agenda is very important. Then the mediator tries to get the options, he tries to generate them, he tries to brainstorm the parties. Yeah? So they come up with options themselves, and then they consider the options and select the most workable solutions, and then the mediation ends with either reaching an agreement or no agreement. So by doing so, or in the course of mediation, there are different tasks and duties, such as, well, some of them also, I'm not going to go into details here, but you might say that independence and impartiality is the same thing, but independence means from outer environment, and impartiality, it's your attitude towards parties. Disinterestedness, you should not be interested in the outcome. Neutrality, yes, you should not be biased towards one of the parties. Professionalism, also drafting legally enforceable agreement. Competence, respect to the parties, and ideally, a mediator should be somewhere in between a facilitating agent, so passive mediator who says, please rethink your positions, and a hyperactive one making proposals. Ideally, it is in between. And quality of mediation, it should be fair. This is something which is also to be found in the preamble of the directive, right? So I'm not going to go through the preamble in detail because this is also in the preamble. Fairness, proper balance between necessary formalities and less stressful character. Expediency, as I said, cost effectiveness, it's relatively cheap. And it's also a form of restorative justice which serves better weaker parties. It has voluntary character, yes, and it's even stipulated very firmly in the Code of Civil Procedure. Acceptability of the person of the mediator, for example, and of the outcome. Confidentiality is very important because there is even a case, there is even case law in the ECJ regarding that issue. And equality of the parties. There are sources of law, also just to look at them. International, you have model law. You have regional Council of Europe recommendations stemming from the 80s and then 2002. And you have the EU law, and there are more, yes, there are more. There's a directive on ADR, consumer disputes, and there's ODR, which means online dispute resolution in consumer disputes, but I'm only referring to the one which is binding, it's binding, but also it is only about civil and commercial matters. Yes, and aim of legislation is presented in the preamble, as I told you. Basically, it's the same as the quality of mediation, which I referred to previously. But the scope is limited to cross-border disputes only. Whereas when I refer to Poland right now, because I have like, how many minutes? 5? 10? Yeah, 10? Okay. So I will come back to Poland, but right now I can tell you that Poland has chosen, and actually it had been done before the term of the time for implementation has lapsed, because Poland introduced the law before. So like it was already in place in 2005 and 6 in the Code of Civil Procedure. But because we did it, there's no, well, also there's the principle of non-discrimination, yes, and the principle saying that you cannot have a worse position in a member state if you're a citizen of another member state procedurally, right? So also the procedural justice and equality. Therefore, there's no problem, the Commission sees no problem in the fact that member states may choose to implement the directive or to have some legislation in place which does not differentiate between cross-border disputes and purely national ones, right? So this is applied to both in Poland, at least. But acts that are excluded from this directive are acta iure imperii, so where the parties have no, their rights and duties are not at their disposal, and this is how the directive refers to it, right? So for example, administrative law, revenue, etc. will not be, tax law will not be within the scope. And also the person of mediator is defined the most important thing is that it has to be, he has to be impartial and competent, and there are problems with the latter. Because in fact, there are no strict rules so now I'm telling you that something which is not to be found in the directive about the minimum standards of their professional skills. Right? So that's a problem. Maybe this is enough, right? Maybe, but maybe not. Maybe you should be required to repeat the trainings every now and then, right? Which you're not really. As a rule, yes, but it depends on the mediating center. And of course, member states must ensure quality control mechanisms and training. Well, this is a general statement. I have to tell you that some of you are or have been my students and should know, at least I hope. And even though those who were not, should also know. I hope that directives just give the aim, yes, I mean they state the aim to be achieved by the member states, leaving the methods to the member states, right, and the form. So some directives are more detailed, some are less, some norms would be directly effective, some not, right, but this is, well, I don't know, this norm should be regarded as directly effective. The member state must ensure quality control mechanisms. It's very general, right? So this directive, I would say, its main problem, but also the reason why Commission is still satisfied with its implementation, because it is, the Parliament is not, however, and I will come back to that, is that it's really quite general. Yes, it's quite general. Also, confidentiality is stipulated as one of the features, unless or except where this is necessary for overriding reasons of public policy. And I'm not going to read out loud, but you can read for yourselves what they might be, or where disclosure of the content of the agreement resulting from mediation is necessary in order to implement this agreement. So this is quite logical. Enforceability, sorry, quite tricky. Member states should ensure the ways to make mediation agreements or settlements enforceable by courts, but this is also up to the national laws, how to do it. And there are some competent authorities, which also range, they depend on national law, but the list must be notified to the Commission and made public. And you can access it on the portal of the Commission and the portal where the information is provided on all member states, right? So you will know what the authorities are, which may issue also authentic instruments, not just judgments, not courts. So they don't necessarily have to be only courts. And this is quite important as well, and also it shows up in some judgments of the ECJ, some recent ones, relation to litigation and arbitration, so other proceedings. ADR is, arbitration is also a means of ADR, but litigation, of course, the court proceedings. So the important thing is that parties are not subsequently prevented from initiating judicial proceedings. Or arbitration in relation to that dispute of course, by the expiry of limitation or prescription periods during the mediation process. So it does not exclude other ways of dispute resolution. Roles of courts and sanctions are also provided for by the directive, but very generally. So member states are free, the directive says, to provide for incentives or sanctions to promote mediation, and it happens. It ranges from country to country, but some, for example, reimbursement of fees, yes, is one way to. Is it a hard shove or a gentle nudge? Reimbursement of fees. You don't go to mediate. You refuse mediation. In fact, you are now required by the law, yes, if you have you file a lawsuit, and there are elements of the lawsuit which are necessary. Yes, so one of them is that you either agree or did or not agree to mediation. If not, then you state reasons. Why not? Okay? And it may affect you adversely at some point, financially. This is basically in Poland the only way. Financial. So there is gratification if you come to mediation because your court fee will be reimbursed, for example. Right? So this is one way to do this. You're not otherwise punished or sanctioned. But there are some more severe sanctions in place in some member states. And court may invite the parties to use mediation in order to settle the dispute. In Poland, you will see how it's done. It's not perfect, right? Because, for example, the court cannot do it throughout the proceedings. It may only do it until the first hearing is finished. Right? So, and then only if the parties decide of their own initiative that they can have recourse to mediation. Also, I told you, I've mentioned, and I'm finishing in 2 minutes, that the EU Commission has issued a report recently on implementation, because obviously in every directive you have the review mechanism as the Commission and gathers or collects the opinions of stakeholders and checks those implementation in all member states. So the Commission, this is not so important, but the difficulties identified were that, and this is not surprising, at least in Poland, I would say, lack of a mediation culture in member states. Yes, we have been a communist country where nobody trusted nobody else. Yes, I mean, there was distrust, there was fear, yes, and there was no mediation culture, to put it gently. Sanction was something which you would expect, rather than trying to deal with the problem between yourselves. Insufficient knowledge of how to deal with cross-border cases, and that's why Commission advocates more information campaigns, etc. Training standards, codes of conduct. There is a European Code of Conduct which is not non-binding, it's like a model law, but there is one for mediators. So obviously this is something which has to be done by member states, and it's not really sufficient. Cultural change is still necessary, and especially the parties, lawyers and judges remain reluctant to refer parties to mediation, which is also connected with the lack of mediation culture. But generally, the Commission says that there's no need to review the directive. However, a year later, the Parliament said that there is a need to review it. And, for example, that there should be EU-wide quality standards for provision of services, that there should be registers of mediation proceedings, and information campaigns. I'm skipping now the case law, but it's just there. I'm not going to go through the facts and the judgment, but basically, in the first case, there was a constitutional court decision before, so the court decided, the ECJ, not to decide it. It was not necessary because some national provisions were already or had been declared invalid. And in the second case, there was a decision based on another directive, the one on consumer dispute resolution, but it was quite important that consumers should not be required to use advocates' services. Yes, where this requirement was in place in Italian law. So Italy should not do it, nor any other member state, right? Because this is not in line with the directive. And now the Polish perspective for just 1 minute. I told you that it's only about the civil procedure code, and I referred to Polish solutions all along the way. But basically, it's enacted in Articles 183, uppercase 1, which is like, well, how do you say it in English? Like the subsection? No, the znaczkiem. Index, exactly. Thank you. No, just kind of, I lost it. To 15, right? So it was added. It was kind of added inside the code. Yes, and this is about mediation. mediation. So basically, once again, voluntary participation of parties is also based on Article 45 of the Constitution. Parties' agreement, mediation agreement, even if implied, is required. And if you have an agreement, there's also one important thing, that conclusion of such an agreement does not prevent the court from hearing the case in civil proceedings. If, however, the defendant raises the defense of concluding the mediation agreement, the court will refer the case to mediation proceedings back. And so this is quite important. And, well, there are some sanctions for unjustified refusal to participate in mediation. Well, there's one thing which I wanted to tell you about expediency. Yes, everything has to be done immediately with proceedings. So a mediator is appointed immediately. He also must immediately notify the parties if he refuses mediation for some reason, because he sees no solution here. He also sets the date immediately and then files the report with the court. Also, approval of the mediation settlement, the mediation agreement should be done immediately by the court, if it's enforceable, of course. Well, and this is important. The last thing which I'm going to talk about from the Polish perspective is that mediation should be completed by 1 month, within 1 month. But on the other hand, if you have the 6 stages which you have to complete, sometimes it's not enough. But the parties can ask the court to extend. However, the court does not have to agree, yes, and it may turn out to be unfeasible. There's the e-justice portal where all information can be obtained, so I refer you to that, yes, and also on the state of implementation of the directive in Poland. And the last thing I want to tell you, as legal practitioners now or in the future, especially, is something which Judge Posner has done. I think it's the only judicial decision, verdict in the world where he actually inserted, by the way, breaching copyright, which was raised by the ABA, the American Bar Association. He inserted pictures, which he found on some website. Yes? One of them is of the ostrich, and one is the attorney behaving like an ostrich. So the thing in Poland, and the problem in Poland and some other member states where there is lack of mediation culture, is that also the attorneys, the advocates, pretend that it does not exist. Yeah? Why is an open question. My idea is that maybe because they fear their fees will not be too high when mediation resolves the problem quite early on, right? So, but this is something to think about, right? So I personally advocate mediation from my own experience and as an academic, so this is what I wanted to convey, and thank you.
Thanks, very good. With all thoughts turning to food, as someone who spends a lot of time with various entrepreneurs, I think that they look at mediation in the way that English people look at flaky, which is that you can explain to the English guests later what flaky is. But they're aware that it exists. There's a concept of something there. We're not sure whether it will be a good thing or a bad thing, and you're never really sure until you try it. And then whether you try it for the second time depends largely upon the quality of the flaky that you got the first time. Some people will try flaky and never try it again. Some people will try flaky and become addicted to it and never look back. And so we need to make sure that the mediation of flaky are of the highest quality. And on that note, we have no flaky to offer you. But we do have food and drink. Before we go, could I just ask you once again, on behalf of all of us, to extend your thanks to all of the speakers who spoke here today, and say to those of you who are not from Gdańsk, welcome to Gdańsk, thank you, and zapraszamy do kolacji.
If somebody gives you answer, let me know.
No, you could look at the buffet outside now, so they will probably know what you did.
I go to a question I asked. What time is time? You come to Prague.
Yes, Prague is 3 o'clock in the morning.
Yes, I'm missing one, so we have some so put it in my diary before somebody puts the anything else.
Rue, it's 3 o'clock in Prague, isn't it, kickoff? Yes. And also, this again.